Welcome to another exciting episode of Dost Isms. I know I said I was going to read to you, but this one's an important one. This one's an important read that I think we need to go through together. And this has to do with this patent assignment here that is between Surety LLC and Mr. Addison M. Fisher. Now, I want you to imagine that, put your name in Mr. Addison Fisher here. So, in other words, if I put my name here, it'd be Mr. Kenneth W. Dost. Okay, now I'm the receiving party. That means I'm the grantee or the assignee of all the things that the assignor, which is Surety LLC, will be assigned, is relinquishing to me as a secured party, which is Mr. Kenneth Dost, and here, or as the case may be here, Mr. Addison M. Fisher. And so let's go through this together because what they've done here is they have taken our capitalized name. So put your capitalized name where it says Surety LLC. That's the grantor, the assigner. That's the person that's our artificial person that was taken from us by an intermediary, by an attorney, okay, taken from us, and they're acting as an intermediary, and they're performing all the duties within what I'm going to read to you here that you and I should be performing had we known that what was taking place here. But of course, it's impossible for us to even do these things because it's all automated, and there's just no possible way that we can do these things because we've been disabled and we're disadvantaged by the business processes and by just the attorneys that have rigged the system as it is. And so, what I want you to imagine then, imagine yourself as the grantor that is now also not just the grantor, but also the grantee, the assigner and the assignee. Okay. And so let's go through this. And this will be eye-opening, I think, for everybody. I think this will piss off a lot of people as well as it should. Now, what patents are we talking about here? First of all, let me go back down to before we read this agreement, let me talk about what patents we're talking about. The patents that we're talking about in this case are these ones here. Digital document authentication system, a digital document time stamping with a catenate certificate, method and apparatus for self-authenticating digital records, method for secure time stamping digital documents, method for secure timing digital documents, method of extending the validity of cryptographic certificate, and secure messaging system. And then as it goes around the world into the WTO, I'm sorry, into WIPO, it goes to Australia, Canada, China, the EU, Japan, New Zealand, and I believe that's it. Patents and also to Brazil, Japan. That's the patents pending in Surety LLC. Okay, as of 2007, and so these are the United States patents that go overseas to these various countries. Okay, let's see, Exhibit C. And these are the These are the list of trademarks. That's digital notary, surety, surety SP, absolute proof, surety, and the power of proof. Now, let's see what else is in here. Okay, this is assignment of copyrights. We'll get to that in a minute. But let's go through this together. This is not going to be, that should be eye-opening. It may not be too exciting, but it'll be eye-opening. Like I said, imagine yourself, you're the grantor here, okay? You're the uninformed grantor. Okay, so everything that's talking about the grantor and the assigner's duties is what an intermediary who stole our artificial person is putting through all these processes for the profit and gain of themselves. Okay, making us the surety. But in this case, what you have is you've got the all caps name that is given it to, that's actually assigning it to the secured party, which is an individual person, which would be us if we were to put our name inserted into this. So we can skip the amounts here. Well, the amount is $10 million we're talking about here. But let's say whereas the obligation of the secured party to make such a loan is conditioned. Now, secured party, remember, being the individual person, the upper lowercase, living, breathing person, to make such a loan is conditioned upon, among other things, the execution delivery of this agreement by the grantor. Let me do this here. Before we go on here, so I can highlight things, let me do this. Let me go ahead and blow this document. It's PDF up a little bit so that I can go ahead and highlight things. So while it's doing that, these are the things that that we're not aware of. This is the trade secret. I'm reading to you the trade secret that is kept from us. That keeps us in bondage. That has been really amplified in the past 25 years and is really, well, it was taken from individual persons that would be administering to these things into an automated patented system where all the contracts, all the licensing agreements, everything is recorded within patents and trademarks. And so that's why everything that we're dealing with here is the origin of is in patents and trademarks. It's where these agreements are that made us a surety, they made us the guarantor, that made us a debt slave, was all here in patents and trademarks. And these are the things that we were made ignorant of. We were under the impression that when we got a mortgage loan, that was an ordinary course mortgage loan. Well, it wasn't. And this doesn't apply just to this. This applies to everything. This applies to credit cards. This applies to government services. This applies to financial services, insurance, everything. Everything as anything is patented. And the number one point about all this is that our artificial person was taken from us, separated from us, alienated from us, made a foreign entity, and made us as the surety and guarantor for all these things. So this is about done here. So I can highlight as I go through this thing. So it's got another 30 seconds or so to go. Actually, about almost done right now. Okay. Okay, perfect. So we're back where we at now. Okay, good. Now I can highlight while we go through this thing. And like I said, this is going to be a long one. It may be kind of boring, but I think it's important that we do go through this thing. We read through this thing together. So let me comment. Okay, here we go. So, okay, where is the obligation of the secured party to make such a loan is conditioned upon, among other things, the execution and delivery of this agreement by the grantor, granting to the secured party a security interest and lien on all of grantor's intellectual property and other collateral as defined below, having priority over any and all other encumbrances of the grantor's intellectual property and or collateral. So remember, these are things that we're not the grantor. Well, we are the grantor, but it is the intermediary that is got the power of attorney over us as the grantor, that is making all these decisions for us and really exploiting you as we go through. So see how we're being exploited by all this, and it's probably this will be an eye opener. Now, therefore, in consideration of the premises and other good and valuable consideration is sufficiency to proceed sufficiency of the chair by acknowledged by the parties, the grantor and secured party, and each of the respective successors and assignors hereby agree as follows. Okay, now these are the definitions here. Let's see. Do we need to? Well, let's go ahead and go through the definitions. I think it's important. So copyrights shall mean all copyrights, moral rights. God, that's so important. Rights of attribution. That's another thing that's very important. And like protections in a work of authorship or derivative work thereof, whether registered or unregistered, and whether published or unpublished, both U.S. and foreign, including without limitation those listed in Exhibit A. And I think we will go through those. Well, we'll go back through those in a minute. Annexed hereto and made a part thereof, together with all registrations and recordings. Okay, copyright licenses shall mean all agreements, whether written or oral, providing for the grant by or to the grantor of any right under any copyright, including without limitation the agreement listed in Exhibit A. Okay, Copyright Office, it's our U.S. Copyright Office, intellectual property. Okay, intellectual property means all patents, trademarks, copyrights, licenses, trade secrets, inventions, discoveries, works of authorship, know-how, confidential or proprietary information, technology, customer list, software, and any other intangible rights. Now, trade secrets is what we're dealing with here with mortgage electronic registration systems, was used as a trade secret. It was kept secret from the American people, from American consumers, from American homeowners or home buyers, that this was an ordinary course mortgage loan. In fact, it was not. It was attached to that agreement was a trademark agreement that was not disclosed to us, that within that trademark agreement gave all our rights away. And so this is a trade secret we're doing. excuse me, dealing with here. Know-how is know-how is basically, now that the trade secret is been revealed, has been uncovered, has been reverse engineered. I know how you did it. I know what you did, and that's when we got to nail them on. We know what you did. Okay, other collateral shall mean all rights to the payment of money now owned or hereafter acquired by grantor. So anything, any profits or anything that comes to the grantor is taken from us and assigned to an assignee. Okay. Now, in this case, the assignee is this Mr. Addison, but kind of think of yourself in the position as being assigned. So think of yourself as you're the lender here. You're the one that's lending. You're the one that's got control of your all caps name, your official person, and you're the one that's controlling this. But and then in so doing, you're the one that's going to be getting the benefits from it. But always keep in mind that when we refer to grantor in here, the grantor is the person that has control over our artificial person, that is separated it from us. Okay, so other collateral shall mean all rights of payment of money now owned or hereafter acquired by grantor, whether due or to become due, and whether or not earned by performance, including but not limited to accounts receivable, purchase orders, contract rights, chattel paper, instruments, notes, drafts, rental receipts, receivables, conditional sales contracts, security agreements, installment paper, installment sales, revolving credit charges, general intangibles, and all other obligations for the payment of money, including intercompany accounts and notes receivable, and all documents, contracts, invoices, and instruments evidencing or constituting the foregoing. All security instruments and security agreements related thereto, all property, the sale or lease of which gives rise or purports to give rise to receivables, and all cash and non-cash proceeds thereof, including any merchandise returned or rejected by or repossessed from customers. All of the foregoing may hereafter be referenced as receivables. All other personal property of grantor now owned or hereafter acquired by grantor, so anything that we acquire, okay, both tangible and intangible, including without limitation all inventory, including packaging and promotional materials, equipment, furnishing, fixtures, instruments, documents, general intangibles, all types, negotiable and non-negotiable documents of title, and all rights to insurance policies and the proceeds thereof, now owned or hereafter acquired by grantor and any of its subsidiaries. So they're acquiring all these insurance policies on our behalf, but it's not for us. It's for them to exploit, not for us, because remember, we're the surety. We're the ones that have made the surety here. Okay, but like I said, imagine that you're the assignee in this and the grantee in this. This is what you would be getting. This is what you would be getting back had we known, had the grantor actually been, and these attorneys actually acted on behalf in our best interest as opposed to their own best interest. So patents shall mean all patents, applications, letters patent, and applications for letters patent, and the inventions and improvements therein disclosed, both U.S. and foreign, in any and all divisions, reissues, extensions, continuations, and extensions in part of said letters patent, including without limitation those listed in Annex B. And we went through those patents already. Patent licenses shall mean all agreements, written or oral, providing for the grant by or to the grantor of any right to manufacture, use, or sell any invention covered by a patent, including without limitation the agreements listed such and such. PTO refers to USPTO. Trademarks means all trademarks, trade names, entity names, fictitious names, domain names, trade dress, trade styles, service marks, design logos, and other source of business identifiers, prints, and labels on which any of the foregoing. Now, entity names too, be that, and also trade names. This applies to that artificial person. Foregoing appear whether registered or unregistered, both U.S. and foreign, including without limitation. It mentions those in Exhibit C. Trademark licenses shall mean all agreements, whether or written or oral, providing for the grant by or to the grantor of any right to use any trademark, including without limitation those listed. Okay, grant of security interest as security for payment of all amounts payable pursuant to the note and performance in full of all obligations thereunder and hereunder. The grantor, which we never did it, we didn't do it, The person that stole their identity that's doing it hereby grants to the secured party as security interest and lien having priority over all other security interests the power of sale, which power of sale shall be exercisable only following the occurrence of an event of default. Now, isn't that interesting? That kind of reminds us of an economic collapse, doesn't it? When tens of millions of people were thrown into default because of an economic collapse that was initiated by Merrill Lynch, by the way, that destroyed so many people's lives that forced people into a default, and this is why, because what's in here now that there's no definitive default, they're going to collect on everything that's good that they're going to read in here. In all of the present and future right, title into the grantor. There you go, right there. And into the following property and each item thereof, whether now owned or existing or hereafter acquired or arising anywhere in the world, together with all products, proceeds, substitutions, and accessions of or to any of the following property. Okay. And they'd say, okay, so IP and other collateral, all intellectual property and all other collateral, all renewals of the foregoing, all general intangibles as defined within the uniform UCC connected with the use of or related to the use of, so the use of or related to any and all intellectual property, including without limitation all goodwill of the grantor and its businesses, products, and services appertaining to, associated with, or symbolized by any and all intellectual property and any and all other collateral and use thereof. All income, royalties, damages, payments now and hereafter due and payable under and with respect to any of the foregoing, including without limitation payments under all leases entered into in connection therewith and damages and payments for past and future infringements thereof. Now, we're the ones being infringed upon, are we not? That's right. Okay, the right to sue for past, present, future infringement and dilutions of any of the foregoing, all proceeds of any of the foregoing. Okay, in addition, with respect to the copyrights, trademarks, patents, and the grantor shall concurrently with the execution and delivery of this agreement shall execute in blank. Does that sound familiar to you people that lost your houses to illegal foreclosure? Execute in blank and deliver to secured party an assignment of copyrights, assignment of trademarks, and assignment of patents in substantive forms attached in Annex 1 through 3. The grantor hereby authorizes the secured party to complete as assignee and record in the Copyright Office or the PTO as applicable said assignments upon the occurrence and during the continuance of default and the exercise of the secured party's remedies on this agreement. So when you were defaulted on, and when you were defaulted, that gave them the license to start going after all the things that we're talking about, all the monies, all the revenues, all the insurance, the estate, the trust, everything that they cannot, capitalize on until the estate is abandoned, until you are thrown out by the sheriffs. And that's when everything that is yours goes to them. And that's the game that they're playing. That's the game that we're playing here. Okay, protection of IP and other collateral by grantor, except as set forth in this section, the grantor shall undertake the following with respect to each of the items constituting the IP collateral. Okay, so this is all the things that are being paid on our behalf that we're paying for, though. Because we're the guarantor, right? We're the ones we're the surety of us. So we're guaranteeing all this stuff. So we're paying for this stuff, but because we don't know about it, it's all water under the bridge, right? Because it's being taken care of by the processes that are exploiting us. Okay, so anyhow, so pay all renewal fees and other fees associated with the maintaining the IP and other collateral and with the processing of the IP and other collateral, and to take all responsible and reasonable and necessary steps to maintain each registration. That's what they're saying. So they're saying that we need to maintain each registration, each trademark that we're attached to, each patent that we're attached to, each copyright we're attached to, which is fucking impossible. If for Aquin, for instance, Aquin changes their trademarks like I changed my underwear, I mean, it's that often. So they make it very difficult to be able to even keep any kind of registration. It's impossible to do. They can do it because they've got the technology, they've got the automated processes by which they can do it. We can't do it because if we're not in that closed loop system. Okay. Now, if the grantor's sole cost, expense, and risk take all actions reasonably necessary to prevent any of the IP and collateral from becoming forfeited, abandoned, dedicated to the public. Now, of course, they want us to abandon it. That's the whole idea here, is to abandon it. Okay. The grantor shall not withdraw or abandon any patent, trademark, copyright, or withdraw or abandon any pending patent or trademark applications. In other words, we can't abandon. We can't come in and say, oh, we're gonna, re-abandon this copyright, abandon that trademark. Bullshit. We can do that. We can abandon it because our knowledge is what allows us to abandon this stuff. Okay, so this just goes through the rest of this, the grantor's responsibilities here. And let's get down to the more nitty gritty here of the agreement. The grantor represents and warrants that Exhibit A is a true and correct and complete list of all copyrights. Okay, this is the list that we looked at the back, and Exhibit B is saying that that's correct and true, and the same thing with the trademarks. But let's get down here to okay. Now here, the grantor, that's us. Okay. Well, wait a minute. Let me back up here. Let me go up here a little bit. Okay. Other pursuits, clips with licensing, franchising agreement pursuant to all IP and other collateral is and shall remain free and clear of all liens, security interests, or other encumbrances of any kind in favor of any third party. The grantor, this is us. This is us. The grantor owns, we own, or is licensed to use all intellectual property necessary for the conduct of the grantor's business as currently conducted. So that our all caps name is not a corporation. Okay, it's incorporated to and into the corporations and partnerships and LLPs, LLCs of others. Okay, so it's considered a company. It is a company. Our all caps name is a company, not a corporation. It's a company. It's an entity. It's a special purpose vehicle. It's an industrial property. It's all kinds of different designations that it has. Okay, so the grantor is the sole and exclusive owner of all rights in and to the IP and other collateral. That's right. We are the sole and exclusive owner. Had it not been for the fucking attorneys that came in and stole it from us. Okay, indicated owned or rather than licensed, and no employee, independent contractor, or other third party has any interest in any of the same except as specified in Exhibits A, B, and C. No material claim has been asserted and is pending by any third party challenging or questioning use of the grantor of any of the intellectual property, the validity or effectiveness of any of such intellectual property, nor does the grantor know of any valid basis for any such claim. In other words, we don't know. In other words, they kept it secret from us. In other words, we're dumb shits. We've been made ignorant to this knowledge. The grantor shall have the duty to promptly notify the secured party of any such claim or infringement and details thereof. To the grantor's knowledge, not us grantor, but them grantor. They're controlling us. None of the IP or other collateral nor any use of the same infringes the rights of any third party. Well, yes, it does. It infringes upon our rights. And no third party is infringing any of the IP and other collateral. No holding, decision, or judgment has been rendered by any government authority which would limit, cancel, or question the validity of or the grantor's rights in any of the IP and other collateral in respect that could reasonably be expected to have a material adverse effect on the business or property of the grantor. So this is why this is why we don't have any case in civil law. This is civil law. We don't really have the standing to do it. We don't have the standing to make a claim. Why? Because of all the irrevocable powers of attorney that have been taken on us on the intellectual property side, on the patent law side, which is a separate body of law than civil law. The grantor shall give secured party written notice with reasonable detail within 10 calendar days after following the occurrence of any of the following. The grantors acquiring ownership of or filing applications for registration of any new intellectual property or otherwise obtaining rights to any additional intellectual property. The grantors become entitled to the benefit of any intellectual property, whether as a licensee or licensor. So you see, this is the gig us up on this stuff. Okay, when they're saying they're saying that we need to give secured party a notice. Well, who are we going to give it to? We're going to give it to ourselves. And if we give it to them, I've given notice to mortgage electronic registration systems. You know what? They completely ignored it. So the problem that we have here is even if we can make claims against this, the problem is in enforcing it. And that is the problem. The problem with enforcing these things is because we're too busy fucking around the civil law when we need to be putting pressure on the patent side. We need to put open pressure on the patent side and not make this a secret no longer, so we can all capitalize on it and get our fucking rights back and our property back. The grantors, knowing or having reason to know that any application or registration related to any of the IP and other collateral may become forfeited, abandoned, or dedicated to the public. And okay, this is what we read up prior. This is just a repeat of what we read before. Okay. Now, agreement applies to future. Well, the execution, delivery, and performance of this agreement has been duly authorized by all necessary corporate or other action and do not contravene any law, rule, regulation, or any judgment, decree, or order of any tribunal or any agreement to which the grantor is a party or by which any of the property is bound. That's because this is trademark law. It's patent law. These are the rules. These are the rules of patents. This isn't civil law here. This is rules of patent. So what they're doing is legal in the sense on this side. Now, of course, it's not legal because what they're doing is they're imposing it upon public persons. So these are concealed agreements, not disclosed to us, that they're imposing upon our public person. Okay, and so there's a contract. So if we're trying to prosecute this in civil law, what we're doing is we're trying to pierce the corporate veil, and that's very hard to do in civil law. But I'm not an attorney, so don't quote me on that. That's not any legal advice in here. It's just my knowledge of past 14 years of dealing with this shit. Okay, agreement applies to future intellectual property, security, interest, perfection with respect to all existing and future IP and collateral. The provisions of this agreement shall automatically apply to any of the additional property and rights described in 4G, if we get down to above all, of which shall be deemed to be treated as IP and other collateral within the meaning of this agreement. Upon the request of the secured party, okay, the grantor shall execute and deliver and have recorded any and all agreements, instruments, documents, and papers as the secured party may request to evidence the secured party's security interest in and lien in any of the IP and other collateral, including without limitation filings of financing statements or other documents with the Delaware Secretary of State and recordal of this agreement and other documents at the PTO, the Copyright Office, or any other similar office. So what they're telling us to do here is they're telling us, yes, you have to have a UCC1, but it has to be in the state of Delaware, and it has to be filings with the PTO and the Copyright Office and other similar offices. So when you're talking about filing the UCC1 and doing the things that you're doing to try as a secured party creditor or trying to prosecute your rights on the civil law side, you're falling flat on your face because it's telling you right here it has to be done in the PTO, Copyright Office, and of course, PTO means patent and trademarks. Okay, and it's not being done because we don't know it's being done. So if you don't know the trade secret, how are you going to know how to acquire remedy? And that's the whole point of this thing, is everything that's been done on this private side strips us of all our rights on the public side. And that's ridiculous. It's evil. Let's see. Moving on. Provided, however, the secured parties taking such action shall not be a condition to the creation or perfection of security created hereby. Notwithstanding the foregoing, the grantor authorized the secured party to modify this agreement without the necessity of any further approval of signature from the grantor. Well, of course not. We don't know jack shit, do we? We don't know about this stuff. We're controlled by some Yahoo who stole our identity. Right? Right? Yes. Grantor's rights to enforce the IP and other collateral prior to the occurrence of an event of default. The grantor shall have the exclusive right to sue for past, present, and future infringement of the IP and other collateral, including the right to seek injunctions and or money damages in an effort by the grantor to protect the IP and other collateral against encroachment by third parties, provided, however, now isn't that kind of odd because, they've encroached upon all our rights and everything. This is the way this agreement reads is it's fully exploitative. The grantor first provides the security party with a written notice of grantor's intention to sue for enforcement of any IP or other collateral. So if you are trying to execute something in civil law, maybe you might want to try to serve a notice that you're going to sue on the IP side, that you're going to sue in the Patent Trial and Appeal Board. And maybe you get some results there, but you won't even get results there because that's what we've tried doing. You're not going to get results there. The only way to give us results here is the government's got to correct this. That's it. The government has to correct this. And I've got ways that they can do that too. I can show you the paths for that. But anyhow, that's another subject. Any money damages awarded or received by the grantor on account of each suit or threat to each suit shall constitute IP and other collateral. Okay. Let's get down here. Okay, so a secured party's actions to protect IP and other collateral. In the event of the grantor's failure to cure any failure by the grantor to perform any of the grantor's obligations hereunder and/or the occurrence of a continuance of any event of default, the secured party acting in its own name or in that of the grantor may, but shall not be required to, act in the grantor's place and stead and/or in the secured party's own right in connection therewith. In the event of any material infringement by a third party of any of the IP and other collateral, the grantor shall promptly notify the secured party of such infringement and take all reasonably necessary steps to obtain the cessation of such infringement and recover all damages resulting therefrom, including after and during the continuance of an event in default, such as the secured parties deems reasonable and necessary. If the grantor shall fail to take such action within 14 calendar days after such notice is given to the secured party may, upon notice to the grantor, but shall not be required to, itself take such action in the name of the grantor, and the grantor hereby appoints a secured party, the true and lawful attorney in fact of the grantor in pursuant to Section 9. Okay, so does that not sound like attorneys suing you? They're really kind of acting in our name, aren't they? When they sue you as Kenneth W. Doss, all caps name, they've kind of taken control of the situation, haven't they? And they're kind of putting their own name in there, which is really our name. That a name of the property that belongs to us. Rights upon default, upon occurrence of any default or any breach of any representation, warranty, or obligation hereunder by the grantor, the secured party may exercise all rights and remedies of a secured party upon default under the Uniform Commercial Code as adopted by in this case in the state of Florida with respect to the IP and other collateral, in addition to which the secured party may sell, license, assign, transfer, otherwise dispose of, use, or otherwise exploit the IP and other collateral in whole or in part as a secured party determines in its sole and absolute discretion. So now you know why there's so many fucking foreclosures and events of default within the mortgage industry. Why credit cards? Why it's so easy for banks and financial institutions to screw you up, so that you miss a payment, or so that they don't record a payment, or whatever they try to do to try to create a default. Because what you got here is you got a fucking gold mine that they're after that attaches to this thing. And that's why, that's the whole point about this thing. If you can throw somebody into default, then you got a gold mine. Well, that violates our rights. That violates our First Amendment rights, our 10th Amendment, 9th Amendment. It violates a lot of our amendments. I got that written down. A lot of our Bill of Rights. It's late, so I'm a little tired. So excuse me if I'm getting a little goofy at times here on this. My thoughts aren't coming together because it's late. Any person may conclusively rely upon. Okay, let's see. Here we go. Where we at here? Any person may conclusively rely upon an affidavit of an officer of the secured party that an event of default is occurred and that the secured party is authorized to exercise such rights and remedies. The secured party shall give the grantor at least 10 days prior written notice which the grantor agrees is reasonable notification under the UCC of the time and place of any public sale of the IP or other collateral. Sounds like an auction, doesn't it? Sounds a little bit familiar, doesn't it? To the extent permitted by law, the grantor hereby waives any and all rights that it may have to judicial hearing in advance of the enforcement of any of the secured party's rights hereunder, including without limitation its rights following any event of default to take immediate possession of the IP and other collateral and to exercise its right with respect thereto. The secured party shall not be required to marshal any present or future security for, including but not limited to, this agreement and the IP and other collateral or guarantees of repayment of any amounts owed to the secured party or any of them, or to resort to any such security or guarantees in any particular order, and all rights hereunder and in respect of such security and guarantees shall be cumulative and in addition to all other rights, however existing or arising. To the extent that it lawfully may, the grantor hereby agrees that it will not invoke any law relating to the marshaling of collateral which might cause delay in or impede the enforcement of secured parties' rights under this agreement or any other instrument, evidence in any of the amounts owed, and all other obligations of the grantor to the secured party, or by which any of the same is secured or guaranteed. And to the extent that it lawfully may, the grantors hereby irrevocably waives the benefits of all such laws. So how are you going to prosecute this in civil law if you can't even bring a claim? You can't. You can't. You got to approach this from the intellectual property side. You got to come from this side, from the side from the private side, the concealed side that they imposed upon us. So, secured party as attorney in fact. This grantor hereby revocably constitutes and appoints and designates a secured party as the grantor. It's attorney in fact. Now, also keep in mind though, if you put yourself in this position of the secured party, this agreement works totally differently, doesn't it? It works totally to our benefit. But the way that they've got it set up, and because we don't have knowledge of this stuff, they've got us as the surety, and it does. And this is how we're exploited by that. The grantor hereby revocably constitutes, appoints, and designates the secured party as the grantor's attorney in fact. So, Own It Mortgage, Countrywide, Bank of America, they've all become the secured party by these hidden agreements here that they've taken from us, irrevocable powers. So again, how are you going to do this? How are you going to override this on the civil law side? You can't. To execute all instruments, documents, and papers as a secured party determines to be appropriate in connection with the exercise of such rights and remedies, and to cause a sale, license, assignment, transfer, or other disposition of the IP and other collateral. The grant within the power of attorney being coupled with an interest shall be irrevocable until this agreement is terminated by a duly authorized officer of the secured party. Well, who's that going to be? An attorney? Court? Who's that going to be? Secured parties shall not be obligated to do any of the acts or to exercise any of the powers authorized by Section 9, but if the secured party elects to do any of such acts or to exercise any such powers, it shall not be accountable for more than it actually receives as a result of such exercise of power, and shall not be responsible to the grantor for any act or omission to act, except for any act or omission to act as to which there is a final determination made in a judicial proceeding, in which proceeding the secured party has had an opportunity to be heard. Well, if we're not the secured party, how can we be heard? Which determination includes a specific finding that the subject act or omission to act had been grossly negligent or in bad faith. Oh, there you go, right there. It's in bad faith. But good luck trying to get the civil court to listen to that. Secured parties' rights. Any use of by the secured party of the IP and other collateral is authorized herein in connection with the exercise of the secured parties' rights and remedies under this agreement and under the note shall be at least coextensive with the grantor's rights thereunder, and with respect thereto, and without any liability for royalties or other charges. Further assurances, the grantor shall, at the grantor's sole expense, do make, execute, and deliver all such additional and further acts, things, deeds, assurances, and instruments, in each case in form and substance reasonably satisfactory to the secured party, relating to the creation, validity, or perfection of security interest and assignments provided for in this agreement, the UCC, or other laws of the United States, or the states of Delaware and Florida, or any and all other countries, or or states as the secured party may from time to time reasonably request, and shall take all such other action as the secured party may reasonably require to be more completely vest and assure to the secured party its rights hereunder or in any of the IP and other collateral, and the grantor hereby irrevocably authorizes the secured party or its designee at the grantor's expense to execute all documents and file such finance statements with respect thereto with or without grantor's signatures the secured party may deem appropriate, provided the secured party shall deliver to the grantor copies of all such financial statements and shall terminate at the secured party's expense all such filings made in error. Now, of course, this sounds all well and good, but again, who is a secured party? Secured party here is really the attorneys. It's not really the attorneys; it's the attorneys' clients. So Aquin, Altisource, Own It, Bank of America. That's being administered to by the attorneys. So you got the intermediary in between there that control everything. They control everything. They control everything. So they're the ones that now, as you understand from my side, law is arbitrary. These lawyers, these attorneys, they've got shit. When you stand on the side that I am on, and you look at what they're doing here, and you understand the patents and the trademarks and all this stuff that they're doing here, this is the rules, it's schemes that is put to codes and statutes, but it's arbitrary. That's why you got to approach it from this side. You can't approach it from the civil law side. You got to approach it from the patent and trademark side, because that's the rules side of the equation. Okay. In the event that any recording or refiling or the filing of any statement or continuation or assignment of any financial statement or any repledge or reassignment or any other action is required at any time to protect and preserve such security interests and assignments, the grantor shall, as sole cost and expense, cause the same to be done or undertaken at such time and in such manner as may be reasonably necessary, requested by a secured party. So these are all the actions of the attorneys, are they not? This is all the actions that the attorneys are doing. In fulfilling its responsibility for the prosecution, defense, enforcement, and any other necessary or desirable actions in connection with the IP or the collateral, the grantor shall hold the secured party and its affiliates and their respective officers, directors, managers, members, shareholders, and representatives harmless from any and all costs, damages, liabilities, and expenses that may be incurred by any of them in connection with the secured party's interest in the IP or the collateral or any other action or failure to act in connection with this agreement or other transactions contemplated thereby. What's the word for this? Unfucking conscionable. Unfucking conscionable. And we're going to cut this one here because this is going long. I don't want to make this too long of one because we've got it we're about a third of the way through this agreement, but I do think it's important that we go through this agreement together. But we're going to call this episode 14 of Surety Agreement, part 1. And we will conclude this one. The next, probably 2 more to conclude this episode. Thank you for listening. Thank you for watching. If you like this content, please like and share and subscribe. Thank you. Have a good night.